Welcome to Lesson 1.8. I'm Mr. Glossinger, and this is about amending the Constitution. In today's lesson, you need to understand a little bit about judicial review in a Supreme Court case called Marbury v. Madison. You'll need to know the rights listed in the constitutional amendments, so break out those flashcards, and be able to describe the process by how constitutional amendments are added to the Constitution. There's three parts to today's lesson. Remember to take some good structured notes. Now, in the first part of today's lesson, we'll just talk about how to directly add an amendment to the Constitution. There are two ways that amendments are proposed and two ways that they are ratified or approved. And the way to think about these is that basically they're proposed at the national level and they're approved by the states. So, getting into the details here. Two methods of proposing, and you can use either one. Basically, 2/3 of the state legislatures, so 38 of the states, have to ask for a national convention. So that's the national part. And they would all send representatives to a convention that we would hold. We've never done this, but it sounds kind of interesting. 2/3 of Congress passing the proposed amendment is the other way. So 2/3 of the House and 2/3 of the Senate. It doesn't have to be signed by the president, though. Then, once it's been proposed officially, it goes to the states. They have to approve or ratify the amendment. 2/3 of the state legislatures have to pass the amendment, or each state chooses some representatives, sends them to a special convention, and 2/3 of the states then have to approve it that way. Now, besides actually changing the words in the Constitution, there can be changes to the way we read those words. And that's the idea behind judicial review. The Supreme Court decided in a Supreme Court case more than 200 years ago, Marbury v. Madison, that it had the power to resolve questions about the meaning of the Constitution. And they can declare laws passed by Congress or orders issued by the president to be unconstitutional. It's the ultimate power of interpreting what the words mean. This is another way that the Constitution can change. During the 1890s, for example, there was a wide interpretation that equal protection of the law meant that we could just separate people as long as we treated them equally. So segregation was constitutional. By the 1950s and 1960s, we had a different interpretation of what equal protection of the law means. And the Supreme Court ruled in 1954 in Brown v. Board of Education that segregation was unconstitutional. So these different changing meanings can absolutely change our Constitution in that sense. It doesn't change the words, just changes what meaning we make of them. Now, taken together, all of the amendments in the Constitution, many of them contain added individual rights. These are restrictions a lot of times on what the government can do. So, for example, Congress shall make no law restricting your freedom of speech or abridging your freedom of speech. And we guarantee that essentially as you have the freedom of speech. It's in the First Amendment. You need to make some flashcards, so pause the video, write these down onto some cards, or write them into your notes, keep track of them. Each one is very important. Now, in today's lesson, we learned about judicial review, Marbury v. Madison, and what that idea of declaring things unconstitutional means, how amendments can be directly added to the Constitution in a real sense, and the specific rights in the constitutional amendments. Make sure you've taken good notes, and we'll see you next time.